Where the reasons behind the law are not made available to the public, the sovereign enjoys outsized discretion over citizens, and lawyers enjoy outsized power to shape the law toward their interests rather than the public's. You might remember that Georgia has tried to copyright its laws, which means that if you go and repost Georgia's annotated, that's the key part here, annotated. If you go and copy the annotated portion of Georgia's statutory laws, they can potentially sue you for copyright infringement or at least issue a takedown or something.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So publicresource.org, among others, because there's a whole bunch of amicus briefs in this as well. Hey guys, let me break in here for a moment. When we were going to publish this video, like literally this morning, I realized that a number of amicus briefs were filed yesterday, October 16th, and several of them are really good. And I just wanted to bring one more to you. So after the Public Resource Org summary, I'm going to also look at the Public Knowledge, R Street, and Wikimedia Foundation's brief and summary, which is pretty epic. So stay tuned after this. But public.resource.org sued Georgia to establish that Georgia's law cannot be copyrighted. We have now covered this twice, I think, where first the district court said that Georgia's law cannot be copyrighted, then the appeals court said that Georgia's law cannot be copyrighted, and that there's just too much inextricably linked material between what Georgia ordered in the annotated code and what could actually be protected by copyright. So it can't be protected by copyright since it's the public law. So this is the brief of the respondent, public.resource.org. Questions presented, that's how these are presented to the Supreme Court and on appeal as well. You'll see the questions presented. So like, what's the summary of the question that we're answering here? We're asking the Supreme Court to answer the question, is the OCGA an edict of the government? And the question is phrased like this. The official code of Georgia annotated, OCGA, is Georgia's only official code of law and is published under authority of the state of Georgia. Quote, Georgia courts routinely cite annotations and other parts of the OCGA that formally lack the force of law as nonetheless authoritative. Every element of the OCGA is finalized under the direct supervision of Georgia's legislative branch. And the OCGA only exists because Georgia law requires that Georgia's statutes be merged with other material before being published, quote, by the authority of the state in the form of Georgia's only official code. Is the OCGA an edict of government and therefore an unprotectable bit of law, or uncopyrightable bit of, well, I guess law isn't ever copyrightable, but is that an uncopyrightable writing or fixing of a work in a tangible medium of expression? And we're just going to read the introduction here because this is 73 pages long. In a series of 19th century cases, this court held that judicial writings and other official legal works published under the authority of the state are not proper subjects of private copyright. That rule, of course, covers texts with binding legal effect, which, once adopted by the state, can be published as, quote, found in any printed book. Importantly, however, it also includes legal works that lack independent binding force if they embody the legal authority of state actors rather than the personal authorship of a drafter or private publisher. The rule is known as the government edicts doctrine. That's important. Let's highlight that. The official code of Georgia annotated is Georgia's only official code and is unambiguously published under authority of the state of Georgia. Indeed, it exists only because Georgia's legislature affirmatively requires that Georgia's statutes be merged with other materials before being published by authority of the state as Georgia's only code. Every bill enacted in Georgia is thus a bill to amend the official code of Georgia annotated. And the creation of the OCGA and all its parts is supervised by the state commission that operates within the sphere of legislative authority. Georgia courts thus regularly cite the OCGA's non-statutory materials, the annotations, as legal authority, and that is unsurprising because the whole document holds itself out as an authentic legal work of the state. The question presented is whether the OCGA is thus an uncopyrightable edict of government or instead an original work of authorship under 17 U.S.C. 102. It is the former, an edict of government. While some of the OCGA's non-statutory content is initially prepared by LexisNexis editors under the state's direct supervision, Georgia has intentionally cloaked the whole work in the state's legal authority. That veil of state approval is convincing enough to confound even Georgia's own courts, let alone ordinary citizens seeking to distinguish state-sanctioned materials from those that allegedly convey only Lexis's private, authorial choices. Georgia can surely let Lexis both publish its own codification of Georgia's laws and also copyright whatever original contributions Lexis wants to make to that private publication. But nothing in copyright law, the seminal cases, the precedential cases, or common sense suggests that by inserting Lexis into a process that begins and ends with state legislative authority and personnel, the state can transform an official legal document that holds itself out as a published work under the authority of the state into a copyrightable or copyright protected work. Georgia contests this proposition by offering an untenable legal rule property rejected by the 11th Circuit and the United States as amicus, as friends of the court who have briefed the court separately. We'll read that in a separate video. On its view, the government edict's doctrine forbids copyrighting only legal materials with binding or independent legal force. But while it is sufficient to foreclose copyright, it cannot be necessary under this court's precedents, as the United States recognizes. What matters instead is whose authority the purported edict conveys, the supposed authors or the states. Having rejected Georgia's rule, the United States nonetheless joins it in arguing that the OCGA fails the operative test for a government edict. Yet this analysis questions only the local court of appeals' reasonable interpretation of Georgia's state law regime, and this court's customary practice when granting certiorari is to follow that interpretation. So, in other words, the Supreme Court is inclined to follow the appeals court's rulings unless they really see a problem otherwise. In any event, the Court of Appeals got it right. The OCGA is, in fact, the official state legal work that it purports to be. This case may well be close, as the 11th Circuit suggested, because of the very state law ambiguities it reasonably resolved. But importantly, any line drawing challenge here arises not from some uncertainty lurking in the court's cases, but from Georgia's own persistence in flirting with the line the cases draw. It would be easy to publish and copyright material like the annotations as private authorship were that all Lexis or Georgia really meant to do. The problem here is that they mean to do something more. They want to make the OCGA legally special for Lexis's commercial benefit and then turn around and deny that there's anything special about it, at least as to the only parts one could conceivably copyright. The government edict's doctrine does not permit that sleight of hand, and there's no reason it should. Whatever such a scheme promotes, it is not the progress of science and useful arts, which is the copyright clause of the Constitution and the purpose of copyright. This court's cases contemplate compilers of legal materials claiming what is clearly or plainly their own work, and this court can affirm just by holding the OCGA to that standard. Legal publishers can surely claim the value they create by annotating otherwise official legal works, whether it be in a book like West's unofficial U.S. Code annotated or Nimmer on copyright. What they cannot claim is a monopoly on the additional value conferred on their supposed authorship when it is, like the OCGA, adopted by or published under the authority of the state. And we'll stop there with that one. But that is the public.resource.org memorandum or brief in support of Georgia's annotated code not being copyrightable. So then here is the brief from R Street, Wikimedia, and public knowledge as friends of the court, they go through some long history going all the way back to Rome and dynastic China and England from 1485 to 1640 to 1642, to Great Britain in 1700s, Virginia in 1846, and then they go into their argument about the edicts of government. We're going to take a look at the summary here and see if it's worth going further, which it probably is. In their table of authorities here, they cite a number of cases and statutes, but then they have these other sources. The Annals of Congress for the 443rd Congress, the Journals of the House of Commons, 125, a history and description of Roman political institutions, a letter to Arthur Lee by Samuel Adams, Law in Imperial China by Dirk Bode and Clarence Morris, The Origins of Freedom of Speech in the Press by David S. Bogan, Books and Society in History by Kenneth Carpenter, English Law Reporting by Michael Bryan, Robert Byrd, The Senate of the Roman Republic, Addresses on the History of Roman Constitutionalism, Guide to Making Legislation, History of England, Edward Coke to the Reader, The Federalist by James Madison, The Letter to Joseph Galloway by Benjamin Franklin, John Locke, An Essay Concerning Human Understanding, The Papers of Benjamin Franklin. This one looks really good. Lots of research done for this one. 25 centuries of history reject the foundation of petitioner's case in contending that it may assert federal copyright law against its citizens to block distribution of the official code of Georgia annotated. The state of Georgia contemplates a bright line between its uncopyrightable statutes and all other edicts of government that lack the force of law. No such line exists. On the contrary, sovereigns since antiquity have promulgated not only statutes but also proclamations, explanations, commentaries, even annotations, all of which, even lacking force of law, carry great weight for the rule of law and the functioning of government. History reveals not a binary divide between statutes and all else, but a spectrum of edicts of government. To fill this historical void in the record, this brief surveys non-binding pronouncements, particularly attached to statutes or codes of law across time and around the world, from Rome and China to England and America. This historical review, which traverses a Roman whistleblower, the Justinian Code, a dark side of Confucianism, an English libertarianism, New York suppressing the press, and the mayor of London being thrown in jail, reveals multiple important lessons that question the basis upon which Georgia's argument stands. First, the law, or that class of government edicts for which the interest of unrestricted citizen access is at its apex, is not limited to statutes of binding force. Law, or access thereto, serves many purposes, advising the citizens on the state's normative views, crystallizing popular opinion on future policy, and delineating the relationship between citizen and state. Non-binding pronouncements serve these purposes too, by demonstrating the logic, motivations, and reasoning of the sovereign. Thus, governments have repeatedly treated non-binding pronouncements as part and parcel of the law. Georgia's determinative distinction has not existed for millennia. Second, concealment of non-binding legal pronouncements has long handed undue power to both the state and the legal bar. Where the reasons behind the law are not made available to the public, the sovereign enjoys outsized discretion over citizens, and lawyers enjoy outsized power to shape the law toward their interests rather than the public's. Third, annotations to the law are unlike the legal treatises and case reports to which Georgia analogizes. Historically, those private writings have been the domain of non-state actor compilers. As such, they are not traditional edicts of government. By contrast, codes of law, complete with annotations, have long been pronouncements of the sovereign's intentions. To treat Georgia's annotations like a private case report or treatise would, then, be incongruous with history. Although this case arises under the Copyright Act, the determinative principles must reach beyond that law. This is a case about the relationship of a sovereign to its citizens and what the state may withhold from them regardless of the legal means. The relevant history is that of the law and how states have published or withheld it. States have sometimes aggressively promoted promulgation and sometimes vigorously opposed it, but history lends to one inexorable conclusion. The law encompasses not just binding statutes but also non-binding pronouncements of the sovereign, and foundational principles of limited government, popular sovereignty, and basic liberty depend on access to the law in whole. So then they're going to go into their argument, and that's where we're going to stop reading with this video. If you want to join us for the rest of this, I'm going to read the rest of this document, about another 20 pages, about another 18 pages, tonight on our Thursday show, which is normally supposed to be on Wednesday, but it's flexible. So our Thursday show, which should be tonight on twitch.tv/lawfulmasses. So we'll go into detail on this document, the United States brief, and I guess other amicus briefs if we find any that are interesting in another video. Let us know what you think about Georgia trying to copyright its laws, about them taking it all the way up to the Supreme Court to try and legally prove and basically make it precedential law that Georgia can have a private third party write annotations to their laws. Georgia can adopt those annotations as the official rule of law and then publish them as the official rule, the official published printed code, and have courts cite that law, but yet you or I can't copy and republish that law without violating copyright. That sounds wrong to me, and the government edicts doctrine is what I hope the Supreme Court will uphold in its entirety and hold that it applies to Georgia's annotated code as well. Let us know what you think in the comments below. So that's our show. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney. Thank you very much to our supporters. This channel would not be possible without your support and sponsorship. Thank you to our supporters on patreon.com/ljfrench and sponsors.com/law. Thank you very much to our October supporters and sponsors. Thank you to Joshua Davis and TandaPay for sponsoring us in the month of October. Thank you to the $50 plus supporters in October: Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, who I think is in our audience right now, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin Hitov. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will be in the crawl in front of me for the outros of the video. I am Leonard French, your favorite copyright attorney. Thank you for joining me. I'll see you in the videos that drop. Love you all. Bye. All right, you ready? Drop. People don't want to see dog butts, they want to see dog faces. Stop the camera. Good shot, buddy. Good boy. There you go. Good girl.